Your Honor. Thank you.
Mr. Watts, anything further?
No, sir, thank you.
Sheila Russell, anything further you need to present to the court?
Nothing at all, no, sir.
I'm sorry, I didn't hear you.
Sorry, I don't, our air went out here, so I got all the fans going. But I was saying, no, sir, I don't.
Okay, all right. Wait. Am I live? I'm live! Oh my god. Let me start this. Wow. Ladies and gentlemen, bear with me. I'm still ushering the other crowd over here. That's still happening. Apparently the music's still playing. So we're dealing with that right now. Yeah, Marty, new music. I told them when the old music ends, the new music begins. Because it's cryptic and meow. Meow. Okay, run away. Yes. Herding cats. Come on, everybody. Mine still has it. There we go. Ladies and gentlemen, let the raid begin, please. Pretty please. Really? Yes? No? Redirect? I mean, I'm pretty sure I've done it before. Okay. I guess I'll just ask people to follow the thing. Ladies and gentlemen. Oh, it did work. Did it work? I had it. So, ladies and gentlemen, this is a crazy one, and it's getting started. It's getting started right now.
It appears to me that you've got some decision-making problems. I get it that you could have a fight or flight response when first confronted with the police, which would cause you to hide behind a tree. But once they find you and tell you that they're going to put you under arrest, fighting with the police just exacerbates the problem. And it's one of the largest reasons I'm going to put you on probation. Because if you're making a decision to fight with the police, then we certainly need to monitor your behavior because you're not making good decisions at that time. The other thing that bothers me is that you're at your house, at your ex-wife's or your mother of your child at 3 o'clock in the morning. I don't care who you are or whose house it is. You don't come to anybody's house at 3 o'clock in the morning without asking for permission first, whether you own the house or not. If somebody else is living there, whether you think it's right for them to live there or not, you don't come to anybody's house at 3 o'clock in the morning.
And this, ladies and gentlemen, is what we saw on Saturday with Mr. James Dash and Judge Hesselink just absolutely taking him to the woodshed over running from the police or basically hiding out when he was invited. He says he was invited to come over to this house. The house which tonight will be discussed in detail with none other than his former, his ex-wife and the person who is the direct other to this next comment.
Your Honor,
That's just not, this is not your time to talk. This is my time. Okay? 3 o'clock in the morning is not normal business hours. It's not even closely related to normal business hours. You just don't show up. That's just common sense. And if you're not able to make that level of decision making, then the court's going to need to monitor your decision making.
Your
make
Honor,
sure
I
that
need
it
to say
is
something.
appropriate.
James, stop.
This is. I know you want to explain your behavior, but it's too late for that.
No, I was invited over for sexual intercourse.
You're not making it any better, Mr. Dash.
Well,
Do what
that's
your
why I was there at
attorney
3 a.m. if we're
do
talking
what
about
your
why I was
attorney
there at 3
advises you to
a.m.
do and keep your mouth shut, sir.
Okay.
All right. I'm going to put you on probation for 180 days. All right. Good afternoon, Mr. Blumberg. Ms. DeGrez, are you still with us?
Yes, Your Honor. Good afternoon.
Thank you. Thank you. We've gone through the docket on the other civil and landlord tenant cases. We're here on this file, which is James Dash versus Rebecca DeGrez, file 25-40752-LT. Mr. Blumberg, I know that you had a circuit court matter. Are you able to be with us for the duration now or not?
Well, Judge, if you recall, we were here a week ago, and at that time you told Mr. Grez to share with me the documents that she served on the court on an ex parte basis. I can tell the court about 10 minutes ago, while I was in the middle of another hearing in front of Judge Mertz, that Mr. Grez hand delivered these documents to my office. That's clearly not complying with the court's order.
Ms. DeGrez?
Yes, I do apologize. Well, given the holiday last week, I did attempt to deliver the documents in person on Friday to Mr. Bloomberg's office, and I found them to be closed. So I definitely apologize. I am like a single mother handling a lot of things, which is not an excuse, but I did make an attempt, and I very much apologize. So I'm ready to proceed. There's not very much in the packet if you would like to look it over.
And Judge, I don't want to restate the obvious, but she hasn't even complied with your direct order. There is no defense to this case. There was a mediation agreement that required her to be out of the premises at the end of March. She is a holdover tenant, hasn't paid rent. And I mean, if we're going to go forward, that's one thing. But if the court considers these papers, I'm going to strongly object to that.
All right, Ms. DeGrez, I gave you plenty of time to mail, to walk over, to whatever you needed to do to get the documents to Mr. Blumberg's office. You will have a chance to testify today if you want to. We will go forward with that, but I'm not going to consider any documentation that you gave to Mr. Blumberg 10 minutes ago or 15 minutes ago or whenever it was today. That's simply not enough time for him to have notice of it, to be able to react to it appropriately. I wouldn't let him do the same thing to you either. So we've got to be fair. So yes, ma'am, you have a question about that?
It's not directly related to this hearing, but there have been times where I wasn't presented with documentation that he presented to the court, and I was caught unawares. But I definitely apologize. It was not my intention. I did try to get it there on Friday.
I'm not disputing what you said, but he didn't have it. Friday was the 4th of July. Everybody's closed. I mean, that's a national holiday. Everybody's closed on the 4th of July, and I think everybody knows that. So whether you try to do it or not, I appreciate the effort, but there's no way that anybody's going to be present to take it on that day. So you will be allowed to present whatever information you have personally, but I'm not going to review the documentation that you submitted in the court file in this manila envelope that you submitted to the court. Mr. Blumberg, this is your complaint. How do you wish to proceed today by way of witnesses?
Well, Judge, I am willing to do this. I am willing to reschedule today's hearing. I have, again, only glanced at these documents. None of them really have to do with the issues, but in the sake of being fair, I'm prepared to agree to reschedule this. I don't care whether you review these documents or not. In my 30-second review of them, they deal with custody issues and things other than the landlord-tenant matter. But I'm willing to reschedule this where the court will have the opportunity to hear all the evidence.
Ms. DeGrez, is that what you want to do too? You want me to consider these documents with this adjournment?
I apologize, Your Honor. I'm just thinking for just 10 seconds.
Yep.
I just want to process
Please
that.
take your time.
I'm comfortable proceeding. I have everything in front of me. I'm organized. I've thought it over and I've studied. So I'm comfortable proceeding. I feel like things just keep getting rescheduled without resolution.
I'm having a hard time hearing you, ma'am. I don't know if you're too close or too far away from your microphone.
No, I'm naturally soft-spoken. I apologize. I'll turn this up a little bit. I have everything in front of me. I'm organized. I'm ready to proceed. I'm well studied on the matter. If you care not care, but you cannot consider the envelope, I accept that. I feel like things keep getting rescheduled to my own humiliation. So,
Mr. Dash, are you with us? If so, I need to see your video on and your audio available.
Yeah, I'm here.
Need to see your video, sir.
Can you see me?
I can. Thank you very much. All right, Mr. Blumberg, go ahead.
Judge, let me, if I may, just take a moment to give you an overview of where we're at in this matter. Mr. Grace is the mother of my client's child. In the midst of a custody dispute and parenting time debate, the parties came to an agreement whereby Ms. DeGrez would be able to remain in the residence owned by my client, and that is at 3051 Otsego Land Drive, Gaylord, Michigan. She was allowed to stay there for a period of time with the understanding that at the end of March of this year, she was to vacate the premises. That was memorialized in a mediation agreement between the parties and signed by the parties and their respective counsel. In consideration of that, certain monies were to be deducted from Mr. Dash's child support obligation. Well, March came and went, and Mr. Grez has remained in that property since then. She's been served properly with a notice to quit and a complaint to recover possession of property. Her defense is, as I read it, or at least as I hear it, is that she's a single mother and she has no place to go. And there were other, I guess, conditions that she believed would somehow allow her to stay in the property. The reality is that she has no legal right to remain there. She's been a holdover tenant since March 31st, and we are simply seeking the court to enter an order to recover the property for my client. Mr. Dash is here today, if necessary, to testify to those things that I've just represented to the court.
All right, Ms. DeGrez, do you disagree with anything that Mr. Blumberg has said?
I would dispute.
You have to
everything he had
talk a
said.
little bit
Oh, I'm
louder
sorry.
so I can hear you, ma'am.
I apologize. I would in fact dispute that almost everything he said and the eviction itself.
Is there an agreement between the two of you for you to be out at a certain date?
Yes, sir. If I may provide background as well, just briefly. I am the primary caregiver, sole caregiver of our shared minor son, Colton, and I have maintained the stable residence at 3151 Otsego Land Drive since November 2019. We did enter a mediation agreement that was dated August 1st, 2024. It did include
Ma'am, every time you look to the side, I don't have the ability to hear you then. So you either
Okay.
need to move the paperwork closer to the microphone or change something somehow so I can hear you.
Yes, sir. I do apologize. The plaintiff and I did enter into a mediation agreement, which was dated August 1st, 2024. There were specific terms in that agreement that do apply directly to our situation now. First was conditions related to payment of the arrears by the plaintiff, which was conditional then on my move out. There were additional financial and logistic responsibilities, as well as within the mediation agreement, there's a mutually agreed upon review to revisit mediation before summer 2025. I did make several attempts with community mediation services. They did reach out to James and Mr. Bloomberg, and my attempts for further mediation were denied. There was no final eviction or move out date unless said conditions were fulfilled in good faith. And there's more. There was no official lease. It was just the date in the mediation agreement. There was no official agreed upon terms outside of that date with the various conditional matters I had already stated. Additionally, Mr. Dash did unlawfully lock me out on March 18th, 2024, violation of MCL law 600.2918. I do have video proof from the Michigan State Police, 2 10-minute videos with Trooper Hop of Mr. Dash changing the locks on Colton and I, and not allowing us
What was
back
the
in.
date on that? What was the date
March-
of that?
March 18th, 2024. So this would have been just as like within process of trying to get the PPO.
Of 24 or 25?
24.
Well, that would have been before the lease agreement or the mediation agreement, I mean?
Yes, and there was no, I asked for a lease. I was never given a lease.
So the illegal lockout, you say that there wasn't a lease agreement. How did he illegally lock you out if there was no lease agreement?
So this was documented in the PPO, not resistance. When he had disputed the PPO, there was like a 3-hour court we had with Honorary Judge Mertz. And so this has all been documented. I would think well documented.
I'm not disputing the documentation, but the question I have is
Oh.
how would it violate the
Yes, sir.
landlord-tenant law if there was no lease agreement and this happened prior to the mediation agreement?
Due to domestic situations at the time, Cole and I were living there by ourselves, and Mr. Dash had become very threatening. So I left the house for the night to go to my mother's. And then when I returned the next day to try to get Colton's things, he had locked us out. And so I had requested police assistance out of Pier, and they did record that interaction. That was Trooper Hop. So there's never been a lease in place is what I'm saying. And I've definitely tried. But I believe it's always illegal to change the locks on someone's place of residence, which it was clearly mine established since November 2019.
All right, but then you stayed with him for the end of March, April, May, June, July, and then August before the mediation agreement, right?
No, sir. Mr. Dash was not present at the home after a domestic incident in August. And
So up to that point, were you residing together?
up until August 2023, yes, until that reported domestic incident, we were. Yep.
So you're alleging that he changed the locks in March of 24,
That is correct, sir.
then you reached a mediation agreement in August of 24.
Mhm.
All right, I just wanted to make sure that I understood your timeline. Thank you.
Okay, I have more in case you need more.
Well, let's take your statements one at a time. Mr. Blumberg has said that there was a mediation agreement, and it appears that you agree with that. And I'm looking at it, it's dated Thursday, August 1st of 2024.
Mhm.
And it does say down near the last paragraph, the opening sentence says, both parties agree that Rebecca will stay in the home owned by James until March 31st, 2025. Am I quoting that correctly?
That is correct, sir. Based on the
Right.
conditions.
You are alleging that there are some caveats to that, some conditions on that.
Absolutely, and other illegal bad faith things.
I'm sorry, I didn't hear what you said.
I apologize for interrupting.
No, you're fine.
I said as well as further actions by the plaintiff that I would consider illegal and against, like, the
All right,
eviction
so
in general. Date.
let me take these things one at a time then, so I can understand them in order.
Okay.
What is your first reason for believing that there's an additional condition in play? Start with your first one, and we'll take them in order.
Okay. And just one little bit of background. The mediation did go for hours.
I'm again having a hard time hearing you, ma'am.
I'm so sorry. I keep trying to speak up. It could be my computer as well. I do struggle with Zoom. So during the mediation agreement, it did go on for hours. I was under like severe emotional and mental duress, and I did agree because I felt I had no other choice.
Judge, I object. First of all, as you well know, what goes on at mediation is confidential. The mediation agreement reflects the agreement of the parties and their attorney. She was represented by counsel at the mediation. So any discussions about what went on in mediation, I believe, is improper.
All right, ma'am, counsel is correct. An agreement is an agreement. It really doesn't matter how it got there or when it got there or under what circumstances it got there. This is an agreement. It appears to me that it was, has this been entered in a court order that solidified this? I assume in the custody proceedings.
Yes, Judge, it has.
Ms. DeGrez, do you agree with that this has been solemnized by a court order so that it's a binding agreement on the parties?
Yes, sir. I have the dates here as well. It was with Honorary Judge Mertz. I would just like to add though, if, just given the context.
All right,
of
so
domestic matters and like that the threat, like I felt very threatened. I still do.
ma'am, whether you felt threatened or not isn't going to change anything. If this is a court's order
Okay.
out of this mediation agreement, it is what it is. Whether you agree to it willingly or unwillingly or under duress or whatever, I can't change that now. All I can do is enforce what it says. So both parties have agreed that there was a mediation agreement. Both parties have agreed today that this was been put in place under a court's order in the custody and parenting time case. So I need to know whether or not there are these conditions that you allege to this agreement. So the agreement says in one sentence that you're supposed to be out by March 31st. What do you believe allows you to stay after that? What are the conditions that you outline? So lay them out for me and we can take them one by one. So what's your first condition?
Yes, sir. Within the parent condition, there was no lease given to myself.
Ma'am, I'm sorry, but every time you turn your head, I cannot hear you. So if you want to have me hear you, you have to face the camera and speak directly into the microphone.
Okay, I'm so sorry. I just get a little nervous. So I think foremost, there was no official lease telling me any further terms. In a lease situation, there's usually like a month to month that happens, and that would just be like the very tip of the iceberg. Is there not being a lease, me asking for a lease, not being provided with one, and repeatedly like trying to go through community mediation. So I'm not even sitting in front of yourself right now. So that would be the first, no lease. There's
Okay,
several things that.
so the first one is no lease. Mr. Blumberg, your response to that?
Judge, there didn't need to be a lease. It was a verbal agreement reduced to writing that allowed her to stay in the home until March 31st of 2025. Any other terms in terms of who was paying the utilities, none of that was an issue or a factor in her ability to stay there. And again, there were no conditions. If the court reads this mediation agreement, there's no language in there that says the right to stay in the property is conditioned upon Mr. Dash complying with all other terms. Because if that's the road where she's going down, the fact is she's been the one that's denied my client parenting time, which was granted by the mediation agreement.
Well,
so there didn't need to be.
I'm not here to, sorry to interrupt, but I'm not here to do parenting time. This is a landlord tenant matter. That's a different court. That's a different proceeding. So the issue is whether or not the fact that there was no written lease allows her, or is a condition, would allow as a condition for her to stay longer. I know of no legal precedent that would say that that is true, ma'am. The fact that there was no written lease may have enforcement consequences as far as him requiring you to pay rent, but I don't know of anything that says that you get to stay longer without his permission. And clearly he has revoked that permission at this point. So I don't know of any legal requirement that says that you are allowed to stay other than by the party's own agreement after you've reached an agreement that says you are to be out on a certain date. So I'm going to deny that as a basis for allowing you to continue to stay. What is your second reason that you believe would allow you to stay longer than March the 5th, March 31st?
Okay, very good. So I do disagree with Mr. Blumberg. Verbally within that mediation, it was known or agreed that the payment of the arrears was how I was going to move out of the house as well. Like it's pretty conditional on it.
So the second basis is that you believe that he had to repay child support arrears in order for you to be required to move out of the home. Is that
Yes,
correct?
sir. And yes, sir. I do have documentation of all the payments, which I've submitted. I think Mr. Blumberg does as well, but I've never seen James' documentation of the payments, so I'm not aware the truthfulness of what was submitted. Yes, so As I took it, the move out date was based on his fulfillment of said obligations. He failed to pay, he failed to mediate, and he acted unilaterally against several court matters, his own lawyer, myself,
Okay.
good faith.
All
Yes.
right, so hang on, let's not get too far ahead of ourselves. So the second reason that you would think you should be able to allow to stay is that he failed to pay the arrears that are referred to in the same paragraph, where it says, Rebecca agrees that there will be a monthly rent of $1,500 beginning the first of the month following the child support arrears being paid in full. Rebecca agrees that the rent money can be credited toward the child support beginning the first of the month of the child support arrears being paid in full. And then James and Rebecca will provide receipts of payments as a credit since March of 2024 to both attorneys on the child support in arrears. So you believe that those three sentences together give you a condition that says that you can stay until he pays off the arrears. Is that what you're arguing?
Yes, sir.
Ma'am, I
requested.
can't, I
I'm
can't
so
hear you
sorry.
again.
I would have liked the mediation agreement, that paperwork to have fleshed that out more clearly for me, just as I had asked several times for a lease, so I understood all of the
No,
terms, and I was
I
never
can't
provided.
change it now. All I can do
Okay.
is try to give effect to
Oh,
what it
yes.
says. So
Okay.
that's the three sentences that you want me to consider on your argument. Is that correct? That's what you think says that you can stay there longer if he doesn't pay the child support arrears.
That's what it says, so, yes.
All right, Mr. Blumberg, your response to that.
Well, two things. I don't believe it says that. And more importantly, he has paid all the arrears. There is no child support arrearage at the current time.
And how do I know that?
Well, Judge, that's a custody and parenting time issue that you're not going to be addressing today. So I can
So
assure
what-
the court that the front of the court would be filing motions against Mr. Dash if he was in arrears.
They have,
All right,
there's several motions. There's 61 items.
all right. Here's the language says that there will be monthly rent of $1,500 beginning the first of the month following the child support arrears being paid in full. From this document alone, I can't tell when payment of rent was supposed to start. It would be some point in the future from the date of this agreement, whenever the child support was paid in full.
Yes, when the arrears were paid
The
in
next-
full was when that would start. There is no
Okay, so
payment
that's-
on the house as well. The house is paid off. That's an important
right.
detail. Yeah,
So-
there's no
Nothing to
payment on the
do with
house.
it.
All right,
The
hang on.
mortgage is paid.
All right, stop. Let me process it. The next sentence says that Rebecca agrees that the rent money, when paid in the future, can be credited toward the child support beginning the first of the month of the child support arrears being paid in full. So there's another in the future thing gonna happen. So rents in the future, rent being being placed towards or credited towards child support is in the future, again, after child support is paid or the arrears is paid in full. And then the only other sentence that's there says that Rebecca and James will provide receipts of payments as a credit for what has been paid since March of 2024. So something in the past. So I got two sentences that deal with something in the future. And I got a sentence that says something in the past, and we're going to try to work all of this out about the arrears. It doesn't say anything about condition on when you are to move out of the house. It is rent for while you are staying there. Which would start in the future if the arrears are paid off. I assume if the arrears are not paid off, you would never owe rent. And all it is all that language is conditioned on rent being, or excuse me, arrears being paid first. But if it is, then you owe rent. If it's not, you don't owe rent. It's got nothing to do with how long you stay in the house.
Okay.
Okay, so I can't find any reason for payment of arrears to be allowing you to stay within the home. Okay, so your next allegation of a condition is that you said he failed to mediate as to parenting time. Is that correct?
Well, that and the
It-
matter of the house.
I'm sorry,
That
that,
was-
that in the matter of what?
The house, that and the matter of the house. That was to be discussed in mediation.
What about the
It's
house
not-
is to be discussed in
Neither-
future mediation?
Um,
What about the house was supposed to be discussed
sorry.
in future
Our-
mediation?
our shared minor child and I staying longer than the date in the mediation agreement was to be
Where does
discussed in the
it, where
mediation.
does it say where does it say that that's going to be further mediated?
It does not, sir. I would have liked it to be included, but I don't have control.
Well, you did at the time of mediation. You could have put that in there, but you didn't. So that's what I'm asking you. But did I miss something? I don't see it within this mediation agreement that you're going to come back and do future mediation on how long you get to stay in the house. Can you point that out to me, or is it not there?
It is not there, sir. You're correct. It would have been nice to have an addendum on that sentence that said, and as well as the house.
All right, well, all I can do is enforce the agreement as it's written. So
Yes, sir.
I'll have to deny your request based on the failure to mediate on the house because it's not within the document. And it doesn't appear to me to be a reasonable reading of what the document says to imply that or to infer that at this point either. Because future mediation is stated previously, I believe, yeah, 4 paragraphs above that, James will have 6 weeks of parenting time commencing in the summer of 2025. If the parties cannot agree on the schedule, they agree to return to mediation. So there is a paragraph in there that talks about returning on a specific item. So you could have put that in there about the length of time you were going to stay in the home, and that wasn't done there. Is there any other condition that you have that you believe allows you to stay within the home?
Yes, sir, I do.
Go ahead.
I may proceed. So the unlawful lockout of 3/18/24, of which I have trooper video from, is that not
Okay,
relevant?
so the lockout
Legal
of
action?
March 18th of 24,
Mhm.
which is approximately 4.5 months before this mediation agreement, why would that allow you to stay longer than so you had the lockout in March, you have the mediation agreement in August of 24. Why would that extend the period for you to stay that you reached in mediation in August? Why would a March event change an August agreement?
Feel free to interrupt me. This might be-
I'm sorry, ma'am, I can't hear you.
I said, feel free to interrupt me. This might take me a minute to-
I still can't hear you for whatever reason.
I don't know if it's the microphone or, here, let me pull that out.
If you're close enough, I get you, but as soon as you back
Okay.
up a little, I can't hear you.
I just don't want you to see my whole face. So, okay, here we go.
Your whole face is just fine. I don't have a problem looking at your face. So you're
Okay.
good. I just need to hear you because it's important.
Okay. Yes, very good, sir. So feel free to interrupt me. I would like to respond to that.
Go ahead. Yep.
This is just one item that reflects a pattern of control that the plaintiff has exercised over myself for over a decade. There was a criminal case that was pending that was led to a plea deal just this past week and additional humiliation on my part.
Judge, I'm going to object to this. It has nothing to do with the landlord tenancy
I'll get
matter.
there.
Excuse me.
I'm
can I
getting
just-
there.
Let me just finish for a
Ms.
second.
DeGrez, hang on,
Yeah.
both parties, hang on. Let me explain it to her. Ms. DeGrez, Mr. Blumberg has the right as an attorney to object to an argument or a statement that the other side makes. So he's made an objection. I'm then going to come to you and you're going to tell me where it is that you're going with this argument, and then I'll rule on whether or not it's going to be allowed. So he says that your argument that decades worth of alleged bad behavior on Mr. Dash's part isn't relevant to this agreement. So I want you to tell me why you think it is.
Myself, yes, me.
I'm
Or Mr.
asking you
Blumberg.
that. Yes, go ahead.
Okay.
Tell me why
Um,
I should consider it.
Okay, I believe this attempted eviction is a clear act of retaliation and harassment intended to punish me for any testimony that I would have put in for the case that was just decided this past week, continually undermine my stability and safety and coerce me into silence. The threats placed on both myself and our shared minor child put us at severe risk of homelessness. Our child will lose shelter, safety, schooling, community, access to care. We're very well established in the community. I work at the high school. So this constitutes child endangerment on Mr. Dash's part for forcing an eviction for his minor child that very much doesn't want to move. Under Michigan law MCL 722.622. So I consider this to be like a retaliatory eviction and leading to child endangerment. I
Okay.
have more as well.
But the idea behind all, you want to explain in a little more detail as to what he's done to you that causes you to believe it was a retaliatory eviction. Is that correct?
I can
All right.
I
So
can do that.
I just want to make sure I understand your argument first. So Mr. Blumberg has objected. You've said you believe it to be a retaliatory eviction. I'm going to give you the opportunity to tell me quickly, but I am going to give you the opportunity to tell me why you believe that this is a retaliatory eviction. Go ahead.
There's been a long pattern of threats and documented 911 calls from situations with Mr. Dash. I've continually felt threatened by both himself and his counsel. There was a letter sent by Mr. Blumberg to the state police, the county police, that I was not even supposed to be allowed in my home until the PPO was upheld by honorary Judge Mertz. So I have felt threatened all along, and there is documentation of it, including the lengthy PPO hearing that we had that supports that. Let's see, I have more. I do feel like it's a violation of my rights as a tenant, as a mother, and a survivor, and I'm just asking for continuity of housing for Colton and I, or even for the parties to agree to revisit this matter in mediation. I would really just like to talk it out, not in this setting. Or an extension. Our son really just doesn't want to move.
Anything else that you want me to be aware of regarding this claim of retaliatory eviction?
Just give me 1 second so I can look over my notes.
Again, ma'am, you're too far away from the microphone. I can't hear you.
Just give me 1 second so I can look over my notes.
Yep, go ahead.
Let's see. Fulfillment of obligations, arrears, engagement, mediation, failed to pay, child endangerment. Oh, I feel that the threats are retaliatory based on my reporting of these incidents. Like I said, there's multiple calls, documentation with both state troopers and county police. And I feel like it is also retaliation for my cooperation and respect for the legal system and for law enforcement. To my knowledge, like it would constitute grounds for court protection, which I currently have in a no contact order, not for eviction.
All right. Is there anything else that you want to tell me about regarding the retaliatory eviction?
No.
All right, Mr. Blumberg, your response to that.
Judge, this is hardly a retaliatory eviction. This is a date in which she agreed to vacate the premises. She has been there improperly as a holdover tenant since March, April, May, June. Here we are in July, and she still refuses to vacate the property and assert some ridiculous claim of retaliatory eviction and child endangerment. The fact is she was a guest in my client's home up until the time where they separated. And when we entered into this agreement, the parties agreed she would stay until March 31st. That's why my client is seeking to regain possession. She has no legal right to be there at this point. We would ask the court to disregard any claim of retaliatory eviction.
All right. Ma'am, I can certainly understand emotionally why you would believe that you are being threatened or that you have in the past been threatened. I can certainly understand why it would be emotionally difficult for you to leave the home and why your son would not necessarily want to leave the home. But I find no legal basis for believing that this is a retaliatory eviction. The date noted in the mediation agreement and subsequently affirmed by the court's order was that you were to stay in the home owned by James until March 31st of 2025, which means that after that time, he has a proper legal basis for asking that you be, in essence, be evicted. He has taken advantage of that. There is no indication on this record that he has, by filing this action, that he has violated some other law or some other court order. I've not heard or seen any indication that the custody or parenting time order has been violated or that the personal protection order has been violated by this request. The request is a normal, legal landlord-tenant law request. It's not, he didn't self-help. My original thought when you first brought up the lockout was that that was in March of 2025 and that this was somehow a self-help cause of action and that you were objecting to that. So I see no action by either Mr. Blumberg or by Mr. Dash that is retaliatory. They are simply using the court system to enforce a legal right that you agreed to when you reached the mediation agreement and that the court affirmed when it entered the court's order in the custody and parenting time thereafter. For that agreement to have any effect, the court has to be able to enforce it. And the court, the mediation agreement and the court order very clearly says that you were to stay in the home until a specified date. You have now exceeded that by a number of months. It was supposed to be March, the end of March this year, so April, May, June, and now we're through the first week of July. You've exceeded that time period. So I'm going to deny that as a reason for allowing you to stay further within the home. Do you have any additional conditions that you believe would allow you to stay within the home outside this mediation agreement?
Did you refuse the child endangerment situation with him then forcing his minor child to be homeless?
The statute that you cite, MCL 722.622, is the child protection statute, and it basically is the definitional section. It does not contain. It does not contain a specified definition of child endangerment. There are certainly definitions of neglect and abuse, child abuse, serious abuse or neglect, all of those kinds of things. But the only child endangerment statute that I'm aware of in the state of Michigan is drunk driving with a child less than 16 years of age in your car. That's called child endangerment under the Michigan statutory scheme. I understand what you're saying, that by kicking your son out of the house at without you having another place to go might be some sort of abuse or neglect in your mind, but I don't find that as a matter of fact today, because I don't know under what circumstances you would be able to move the child. And if you are the parent, as you've alleged, if you are the parent with custody at the moment, where the child is going to stay would fall on you first, even if you were. So if this was a third party that was saying, hey, you haven't paid your rent, I'm going to kick you out, it's not abuse for that landlord, whoever that landlord would be, to remove you from the home. Even if you were to be homeless at that point, it would be your job to find the child immediate shelter. And if so, I can't make a finding of fact that says that his use of the court system to enforce a right that he has is child endangerment, because it's not a statutory phrase or a violation. I also find that it's not neglect or abuse under these exact circumstances as I have them today, because you are able to provide, even if he was to kick you both out, he knows that you are able to provide for the child's immediate safety and find the child an appropriate place to stay immediately thereafter. So I don't find that that is a proper basis for action to extend the time period for today. Is there any other condition that you would propose?
May I just point out a specific law?
Go right ahead.
750.161. And I hear you. I understand what you're saying. In section 161 of that, in reference to Mr. Dash, a person who being of sufficient ability fails, neglects, or refuses to provide necessary and proper shelter, food, care, and clothing for his or her spouse or his or her children under 17 years of age, is guilty of a felony, punishable by imprisonment, etc. He meets all of these things. Like, he has not provided necessary shelter, food, care, clothing. Yes, just to give you, because you had said, and you are correct, that's just like a very simple, like stating what the law is, the first one I named, but this one kind of fleshes that out a little bit more. But I do accept as well what you are saying. I do not feel like we can look at this from an objective perspective, as this just my landlord. This was our family home. We worked for together, paid it off together. There's no mortgage payment on the house. And I'm trying to advocate for myself and my son. Mhm.
I don't have a problem with you advocating.
I do not.
I don't
I just
have a
wanna add-
problem, ma'am. Ma'am, hang on.
Oh.
I don't have a problem with you advocating for yourself and your son, and I think you're doing an admirable job. So that's not an issue. The issue is, that's all that's in front of me today is landlord tenant.
Mhm.
Does a landlord have the right to remove a tenant when there's an agreement between the landlord and tenant to move at a certain date? And the answer to that question is yes, he does. And simply by removing the tenant, if the tenant has a young child, does not cause the child to be neglected or abused, because the tenant can provide for the child's immediate welfare by getting a motel or getting a hotel or going to a homeless shelter or renting another place. So it is not abusive or neglectful, even if the landlord is the father of the child and knows that the child is going to be removed from the home that the child believes is its long-term home. That may have some emotional impact on the child, but by and of itself, I do not believe that it is neglectful to the point where it would overcome the landlord-tenant laws. If you disagree with me, you may certainly report it to Child Protective Services. They may do an investigation, and if they believe that I am incorrect, they can bring that by way of a child protective proceeding in court, and I would review it again at that point. But as of today, the landlord simply enforcing an agreement reached with the tenant for a date to be removed from the home does not amount to abuse and neglect. Do you have any other conditions that you believe would allow you to stay within the home longer than the date that you agreed to?
Let me just look. They are rather backed up at CPS too. They're very busy over there.
I deal with them every day, so I know exactly how busy they are.
I know.
Correct. So
They really
So-
are. They're doing the good work.
Judge,
right.
can I respond while she's looking whatever it is she
yes,
wants
sir.
to? If anyone is neglectful in this situation, it is Ms. DeGrez. She is the individual who cannot provide for her child. My client, at a moment's notice, can provide this child with housing, food, and clothing. So if she wants to go down that road, she is the neglectful parent, not my
Love to go
client.
down that road. Sir, I would love to go down that road. Like what, 230 miles away? 230 miles away, sir.
Stop. Ma'am,
Sir, the false
As I've
narrative
said,
and the humiliation is not acceptable.
ma'am,
I'm sorry.
as I've said before, I'm not going to consider what Mr. Blumberg said, because I'm not here on abuse and neglect. I'm not here on custody and parenting time. I'm not here on any of that. This is landlord tenant. I don't take what Mr. Blumberg said as statement of fact. He's an advocate for his client, and that's all that was there for. So please review your notes, do whatever you need to do, take a minute to think about what you need to do. And then all I need to know is, do you have any other reason for believing that you can stay longer than March the 31st in the home?
Okay. I guess they have a closing or like, yes, I can talk. Very good.
Go right ahead.
I would request the court not to think of this situation as a contractual dispute. It is a matter of child safety, survivor protection, and a parent's right to remain housed while completing a master's degree and caring for our shared son. The plaintiff's actions are consistent, the long-standard pattern of abuse and retaliation, and this should be evaluated as such in any legal setting, especially as it pertains exactly to this. I don't believe it can be looked at objectively as a landlord-tenant typical situation that you describe. I do understand what you have said. I agree with this very much. I would like the court to consider the non-performance and retaliatory motives of the respondent with this. And please just uphold my continued right to reside at my home at minimum until a mediation session can be held and we can agree on further terms. It's in the best interest of our child. But again, like you said, I realize this is not a custody dispute. From my perspective, I felt like it was in bad faith the arrears weren't paid, and that was verbally discussed, agreed upon. And it is to my detriment that it's not an addendum within the mediation agreement. I did request an addendum to the mediation agreement in January as well, and I have been denied continually. That is all, sir.
All right. Mr. Blumberg, do you want any response?
Just briefly, Judge, and I'll try to stay on point. Contrary to what Mr. Grez says, this is a contractual situation. There was an agreement freely and voluntarily entered into by the parties. It specifically gave Mr. Grez the ability to reside in that place until March 31st of 2025. In spite of our numerous requests to peaceably ask her to leave, she refused to do so. And we had no choice but to bring this action seeking the court ordering her removal from the property and retaining possession to my client, the rightful owner. This isn't about custody. It's not about child endangerment. It's about my client's legal right to retain his property. Thank you.
All right. Ms. DeGrez, I can certainly understand, as I said before, the emotional impact that the request to leave the family home and the whole home that you've shared with your child for a long period of time, why that would have some emotional connection to you and why that would be difficult, probably economically, emotionally, socially. However, this is nothing more than a common, ordinary landlord-tenant matter. This is a holdover on a verbal lease, if you will. The parties mediated that as a part of the custody and parenting time portion of your relationship. That was reduced to an agreement. The parties with counsel agreed to have you move from the home on March the 31st. Mr. Dash and Mr. Blumberg are simply asking that the court now enforce that through the appropriate contractual landlord-tenant process. You have been given every opportunity to produce to me a landlord-tenant reason why I should not do that, why I should allow you to stay within the home for a longer period of time, and you've not given me any legal basis for doing so, other than it would be hard for you, it would be hard for the child, and you would like some grace. Unfortunately, I can't make one side agree to something that they do not wish to. The parties reached this agreement. I can only enforce what the parties agreed to. And that's what I'm going to do in this particular case. Mr. Blumberg, do you have a proposed judgment for me to sign today or not?
I do not, Judge. I will provide that to the court tomorrow, certainly at the earliest, or maybe later today. Although it's
All right.
Mhm.
Why don't we do that under a 7-day notice? She would be required to be out within 10 days of today's date. That's the most of time that I believe that I would normally be allowed to give her. So ma'am, you have 10 days from today's date. Mr. Blumberg is going to send me the original and send you a copy of a proposed judgment. If you disagree with, not with what my ruling is, but what his order says, whether it if it differs from what I have said, then you have the right to object to it, and you must do so in writing. If you don't object to it, I will sign it in 7 days, and it will become the order of the court. Do you have any questions, ma'am?
Just, I suppose one, a lease would have been very helpful. The fact that there's not one, I think is a glaring oversight to all of it. Like you said, it's just one sentence. And I begged for a lease.
I don't
It's very
disagree with you that a lease would have been very helpful, but it wasn't there, and I can't go back and change history. All I
Neither
can do is base things on how the law typically works. There are lease agreements where nobody writes it down. It's not supposed to
are
be
there?
that way, but they do that.
Oh,
People let people stay in their house all the time. And if they hold over after they've been told to leave, we do the landlord tenant stuff. So it's not out of the question to have a non-written lease. And so that's what you have in this particular case, a non-written month-to-month lease. You're a holdover after you agreed to go. And so I'm treating you exactly the same way I would treat anybody else that comes before me with the same kind of claim. You have these rights. We went through the reasons why you might stay, and I found for the other side, and I believe that they are being upheld in the proper way to proceed. So all I can say is Mr. Blumberg is going to submit an order that comports with what I've said today. You have 7 days to object to that once you receive it. If you don't object, I'll sign it. If you do object, we'll have another hearing on it, but you've got 10 days period to be out. Okay? All right, that's all for today then. Thank you very much.
Judge, can I just ask one last thing? I want to make sure we all understand.
Yep.
Well, she has the right to object to the form of the order, but not the court's ruling. I'm not sure she understood that.
That's correct. And she has the right to appeal if she wishes, but she'd have to do that appropriately. And I don't know whether the next court would accept it or would adjourn it or hold it in abeyance. So all I can say is that's the ruling that I've made. Mr. Blumberg is going to submit the order, and we'll take care of things in the due course as they proceed on down the road. Thank you all very much.
Thank you.
With that, the court will be in recess.
And ladies and gentlemen, that's it. And that's the wrong song. Hold on. This is how it's done when it's live. There we go. Ladies and gentlemen, thank you for hanging out with me tonight. Thank you for commenting on this video. It has been a fabulously enjoyable affair. That's loud. I need to do modifications because I'm doing things all differently and live tonight and having to manage things all at the same time. And the dogs wanted to go out, like literally with 2 minutes left on the video. Two. But they wanted me to make sure to stop and say thank you to Rhonda and everybody who donated tonight. Thank you so very much. Through the premiere, through the course of the live stream, just helping out, guys. This is Late Night Blues with by Roots and Recognition. Late Night Blues by Roots and Recognition. I got all of them on the list right over here next to me right now. You just happened to ask me at the right time. Hey, for coming out, Living. Hey, for coming out crazy, and Mama, what are you doing awake? I'm surprised you're even still up. He's right, though. We appreciate each and every one of you. Thank you for coming out earlier tonight for the premiere. Hope to see y'all again tomorrow night. We'll have another premiere. I don't do these lives every single night unless something special happens, and this just happened to be something that I thought was pretty daggum special, considering we just saw his case on Saturday. And now here we are, ejecting her from the very house where he was caught hiding behind a tree by the police because he got called over for a booty call. Hey, what'd you know? Aw, cat. Living like a cat, coming through like a king in the end. Love it. Thank you so very much for those those stickers are cool. I like those stickers. It makes me jump every time I see it. I don't even really know what to say for it. Thank you so very much. That helps support the channel. It helps support the little fur babies who are at the back door right now wondering where I am. They hear my voice. They wonder who I'm talking to. Ladies and gentlemen, I am your Lone Wolf Oozle. Oh my gosh, Rhonda. Stop it. Wow, that is an OP sticker right there. That is an OP sticker. We had a KO, now we got an OP. That is a heck of a biomechanical arm. Is that supposed to be cable? That's pretty badass. Oh, the name of the song? Late Night Blues by Roots and Recognition. Late Night Blues by Roots and Recognition. I think it might be in the description, maybe, possibly. I'm not sure. But it's not long. Not long to play out. Means I'm not long to play out, ladies and gentlemen. I'm your Lone Wolf Oozle. I am your host for these here little lives when they happen, and I am your curator for this here channel here at the Court Gallery, and I've got a lot more to come. This is going to be part of a little compilation I'm going to be dropping tomorrow morning for all the people who didn't see the stuff on the live. So thank you all for commenting. That helps out with the compilations that we're going to be throwing together for the extended supercut of the video. I want to make sure we get both of those together all in one little thing. Ladies and gentlemen, that song's playing out, and I'm going to say good night because why not? Y'all have a good night. See you tomorrow, all right? See ya. Are there a few of you still here? Because if you are, this is what they call in the old days a psych out. Not that I'm gonna play another video or anything, which I have hours and hours of that. We're not gonna bother with that, but I am going to play another song because I like it. Oh, Rhonda, you stay until it kicks you out, really? That's great. Oh, my Lord. Yes, chat again tomorrow. I'm watching the back door. I am. I'm actually watching the back door. One of them is at the back door waiting. The other one keeps kind of coming by, waiting for a second, then running back. I'm giving them a good hot minute. We'll stay until the song ends. Love this song. Could you? Night living. Oh my. That's the end of the song. That's it. What? That's it. No more. I'm definitely not going to do anything like that. Not, absolutely not going to. What I'm going to do is say goodnight. Because, ladies and gentlemen, it's been a long night, and Mom's ready to go to bed, and the dogs are ready to come inside, and it's over. It's just over. It's over, right? I said it's over, Dawn. Really? How much more? This can't keep going like that. It has to stop. It has to. Somehow. It's never over! Oh my! I know how to make it stop. Just like that. Good night, ladies and gentlemen.